I'm Joe Tracy, Vice President for Connected Care and Innovation at Lehigh Valley Health Network, and I'm pleased to represent a panel who needs no introduction. But all of their bios, et cetera, are on the app. So we'll stay with what we've been doing without doing any introductions. So this is going to be a little bit different. It's not going to be really a kind of a trial like we've seen before. I'm going to kind of read a case to you, and I believe it's on your app as well. Some of you may have read it in advance. And then we're going to have a discussion about this case around privacy and security, licensure, and the standard of care. So hopefully everybody's awake, so here we go with the case. A 60-year-old male was working on his computer one morning, reading about new reimbursement and privacy laws and regulations related to telehealth. Okay, that should be your first clue. About 15 minutes into the work, he begins to lose feeling in his left side. He attempts to get up from his desk, but collapses on the floor and is unable to get up. His wife, upon waking up, finds him on the floor and calls 911. She is not sure how long he has been on the floor, since he's a very early riser and is having difficulty speaking. The patient is rushed to Rural View Hospital Emergency Department. Upon arrival, the patient is semi-conscious with slurred speech. The emergency department staff quickly figures out that he cannot perform simple tasks with his left arm and has a facial droop. His NIH stroke scale is estimated to be 10. The patient is immediately sent for a CT scan. The attending physician calls Urban Sprawl Hospital and asks for the board-certified vascular neurologist on call. The two physicians begin a conversation of what to do with this patient given the estimated NIH stroke scale value and the verbal description of the patient's condition to the neurologist. During the conversation, the CT results become available and it appears that the patient is having an ischemic stroke. Both physicians and the patient's wife are unsure of the time the stroke began, and the neurologist isn't comfortable with the ED physician's NIH assessment or a description of the case. As they continue to debate the patient's condition and the treatment options, the patient's symptoms worsen. He begins to have a seizure. TPA was not given because the consultation between the attending physician was already at 3 hours and no one was sure when the onset of symptoms began. Over the next several days, his condition deteriorates and he requires complete care. After a week in the hospital with no improvement, he is discharged to a skilled nursing facility where he will reside the rest of his life. The patient remains nonverbal and unable to feed or assist in his own care. During this case, the neurologist was overheard by a nurse in the Rural View Hospital to say, "If I had only laid eyes on that patient at the beginning, I think we could have done more for that patient." This comment was relayed to the patient's wife. The patient's wife decides to file a malpractice lawsuit due to the long-term disability of her husband that may have been prevented or minimized if treated differently. During the legal proceedings, the prosecuting attorney finds that both the Rural View and Urban Sprawl physicians had mobile phones and video conferencing capabilities in their pockets. However, those video capabilities were not used. During the trial, the prosecuting attorney brings up, "If I had only laid eyes on that patient," and brings up that comment and asks both the emergency room physician and neurologist why they did not use the tools they had at their disposal. Both physicians answered they didn't think the technology would meet HIPAA requirements for privacy and security, and they did not want to violate the law. During closing arguments, the prosecutor told the jury that my client is permanently disabled and requires 24-hour nursing care for the rest of his life. It is entirely possible he would have been able to have a productive lifestyle if the physicians had used the video conferencing tools they had at their disposal so that the neurologist could see my client's condition in real time. Unfortunately, they chose not to do this because of the privacy and security regulation. So now we have to explain that to his wife, that the law prevented these physicians from doing the right thing, using the tools that could have allowed her husband to have a meaningful life. The prosecuting attorney closes by saying, How on earth do you justify this outcome to her? Okay? So that's the case. The 60-year-old guy reading telehealth legislation has a stroke. So be careful out there. And you can see how this thing deteriorated. There was no telehealth available. However, the physicians had iPhones or Androids or some mobile device in their pocket and chose not to use them because they worried about HIPAA. Bad outcome. So we're going to look at this case from the three perspectives: privacy, security, licensure, and standard of care. There are no right or wrong answers. And so I'm just going to kind of let the panel address this right now from the HIPAA and security standpoint.
So just as a frame of reference for my presentation here is, I'm Marilyn Heine, past chair of the Pennsylvania State Board of Medicine, but I just want to make sure everyone is aware that I am not representing the board per se or the Commonwealth, but just providing some regulatory insight into these issues. So one of the things that we always consider is what exactly is the right thing. So for example, if a more complete physical exam had been done and a more accurate NIH stroke scale level had been reported, that would have certainly facilitated better communication, which is always really important. And the other issues with regard to privacy and security are, you always have to prepare for what is going to be the worst case outcome, what's going to be the worst case scenario that you have to protect for. So yesterday at our sessions, we were talking about reasonable care, and we're talking about always having a backup and a fail-safe. So I can go into some of those other points, but I don't want, and we can have the other members talk about some of these things, and then I'll chime in after that as well.
So, I'll speak to this as, obviously I run a telemedicine program, but I'm also a practicing emergency physician. So I think it's probably good to go early on and talk about it a little bit from the clinical side, since I'm the person on the panel that does that.
I do too. I'm an emergency physician.
I know that. Yeah. I know that. But you passed on that identity.
Sorry, that's another hat.
You went for the regulatory hat. So anyway, one of the important things in treating a stroke patient is the time of symptom onset. And there's something called the last known well time. So if you just wake up and you have a stroke, we have no idea when that happened, and you don't fit within any window. So one of the things that's not brought out by this case, but I might actually really try and do in the ER, is pin down when did the symptoms start. I think we can guess that the patient made it out of bed and made it to the room before he couldn't walk anymore. And we can guess that most people, when they open up their computer in the morning, respond to email. And so it's one of these things I might have said, do you, the patient or the spouse, have an iPhone, and can you see when the last email was sent? Because that might tell me a last known well time when he could use his arms to type, unless it said, I'm having a stroke. But it would be a nice way to get at it. But otherwise, although it's not really the issue we're here to discuss, if I was the expert in a courtroom on this, I would say, I don't know if he qualifies. I don't know if he got up at 1 in the morning, in which case he wouldn't meet criteria, or got up 10 minutes before the spouse found him, in which case he would meet criteria. And that becomes one of the pivotal medical issues that I don't think we need to dwell on too much with this respect, but it's how then could we get there and treat the patient. So I just wanted to lay that framework from a true medical perspective early on, and we can then ignore that and assume he might be within the time frame for the rest of the discussion.
I just have one quick question for Judd with regard to the time of onset. How does the Dawn trial that actually show that with an interventional procedure, you may actually have a window up to 24 hours. How does that influence your thinking on this? Or is it too early to say because of those results?
I think it's too early to say for standard of care. It would depend on the hospital, would depend on the capabilities of both the transferring and the receiving hospital. And it's hard to say shortly after a trial it's standard of care, but it certainly would have been, as the doc said, an opportunity to do better.
Okay. So I have this unique distinction amongst many others, both bad and good, that when the HIPAA privacy and security rules were authored, I was on the reg writing team because I was a Fed back then.
Wow.
Yes, I don't admit that to many people for obvious reasons. And don't shoot the messenger, because I did not come up with the legislation, I just helped write the regs. And I remember sitting in a room with 30 other bureaucrats. See, this warrants me getting a picture taken, because I wrote the reg, and so now.
Would people please tweet and give him blame?
Thank you, Judd. When we were in the room, I think the first sort of overarching rule was to protect individuals' data from unauthorized use, but never to be so overreaching with the protections that it would harm somebody's care. And that's a very delicate balance to try to achieve. Because at what point in time do you have to authorize the use of data or take that authorization into your own hands because a patient's life is at risk? With this particular case, what I found interesting about it when I read it, because I actually did the prep work before sitting on the panel, is this is going to go on for 45 minutes. I thought that this sort of really got back to when the rule was created, that there are certain quality measures, particularly around stroke, where they are really grounded in evidence about what a doctor should do at the time a patient presents with the symptoms of a stroke, all the way through until they are discharged from the hospital. And they are evaluated on the basis of whether they are meeting those measures. Now, that assumes at times that the patient is like, I'm feeling unwell, and they walk into the ER and they're given the stroke scale, there's a measurement taken, judge says this patient's at serious risk, and then implements the appropriate interventions to take care of the patient. That is not always reality, and it is especially not reality in rural health communities, where a patient may already be in the point where they are having a stroke or had a stroke, and care has to be provided immediately. At that point in time, the physician and those around them should be using the available technologies to provide that care that is essential, and document that in such a way so that it is clearly known about when the data was used and why it was used. Because what was also discussed back then, and what is still discussed today, is if you're going to be leveraging data in order to be taking care of a patient, and you're not able to get, at times, because of the situation, the essential consent, you have to have provenance. You have to know where it originated from, where it ended up. Because in the event that there is a jurisdictional, an issue regarding the law, that is something that has to be demonstrated. But I just remember that there were a number of privacy experts saying, we don't want anybody to hold our data. We don't want anybody to use our data. I tell the story a lot, and I'm not going to tell the story you think I'm going to tell, which is, my father, who is a robust 75 years of age, who I think knows what I do for a living, I'm not real sure, but has said to me constantly, I love you, you're my son, you will never look at my medical data for as long as I'm alive. Even though I pretty much know what's already wrong with him and I don't really need to look at his data. And he says that because out of a fear that it's going to be misused. But I told him, if you're in a situation where you're in life or death, a doctor has to intervene right then and there, are you seriously going to tell me that you don't want the doctor to look at your data to take life-saving measures? And he went, of course not. I'd want the doctor to do everything that they could do to save me, unless it was a foregone conclusion. And so I said, that's the whole spirit of what was decided by that rule, which is we don't want to inhibit a physician or a provider to not be able to deliver the necessary care at the necessary time. But we also want to try to balance not having to deal with unauthorized access to data. And of course, as I'm sure everybody on the panel would probably agree, a lot of this is perception-based. And that's gotten a lot worse over the last 2 weeks, because we all decided Farmville was a terrific game and we wanted to know what Harry Potter house we would end up in. So we filled out those polls in Facebook. Not everybody did that, obviously, but. And then so Facebook had all this data about your personality and apparently sold it to a group that then used it to do whatever malicious things they were going to do with it. And so that has stoked people's fears about who's gathering what and what are they using it for. But when it comes to healthcare, there is that balance to draw.
What Harry Potter house were you?
Guess.
I think you're a Gryffindor. Quick, we're going to do a little quick experiment here. Raise your hand if you have a cell phone, smartphone. Okay. Keep it up if you ever keep them up. Keep them up if you ever use like an iCloud backup or Google Cloud or whatnot to store your phone pictures and stuff automatically. Keep them up. Okay. Keep your hands up if you're some sort of healthcare professional or provider. Okay. Keep your hands up and be honest if you have any pictures of patients or any of their stuff on your phone. Okay. We know that the predicate behind some of this hypo is the hospital's policy on not using unsecured devices to transmit health information, overshadowing the individual professional's responsibility to provide care to patients, including in an emergency situation. That's part of it. But I would posit that even a number of you who dropped your hands super fast may have, at some point in time, taken a photo of a patient site location, if only for the convenience of sharing it with other professionals for care. It's another reason why, in the HIPAA rules, right, there's an exception for authorizations to share information, share PHI freely between and among providers.
Mm-hmm.
Just for what it's worth, the perspective I guess I'm trying to bring here is. I'm with an industry trade association that largely is coming from the perspective of small and medium-sized entities that are startups in the digital health space, trying to get into the healthcare game. I think that probably the reason, and my association, for what it's worth, advocates widely on their issues, but I think the reason we have a dedicated initiative to it is that my belief, probably, I wonder if this may be a little bit of a hot take or maybe not, but is that of all the sectors in the economy, the one that has probably least utilized the power of connected health tech or connected technology might be the healthcare space. And there's a bunch of legitimate reasons for that. It's one thing to disrupt a revenue stream from a taxi cab driver who has a medallion to someone in an Uber, I think, as compared to the healthcare space. But that's my interest here. I think as far as the HIPAA laws and this hypothetical, for what we hear from these smaller companies who are trying to get into the game and grow is that the HIPAA is a major area that they have to address. If they don't address it, for example, if they're trying to pitch some investors for more money and they can't quickly and confidently answer questions about HIPAA's application, then they run into issues and they may not get that funding. There's some areas in the law, probably. I know that the HHS has issued guidance to supplement the rules as far as some emerging forms of delivery or emerging technologies, I guess. Example, cloud computing guidance was issued rather recently that we worked with the agency on, but we still await direct guidance in writing about text messaging. That's a problem, I guess. I would only add that I think that with this hypothetical, if the outcome, if this hypothetical were to really happen, I would argue that this application of the laws is basically not in the public interest. That the video tools that they had at that the neurologist had at their disposal were not used purely to avoid liability, and it resulted in something catastrophic like this. That is, I don't believe that was the intention of Congress when they created the law, nor the intention of the HHS when they put regulations together based on the law, and maybe based on that, from this again, just from a public policy perspective, it should all be revisited if this hypothetical were to happen.
I'll also say that in clinical practice, and maybe I'm wrong legally or from a regulatory point of view, there at least to me are some logical workarounds. So real case, have a gentleman in the ER that has a whole host of chronic problems that I can't tell, does he need the procedure I think he needs or not, but I know his doctor can tell that. So I call his doctor and say, and we got lots of telemedicine at Jefferson, and I said, can I put you on and can we do a call so I could bring you into the room and see the guy? And he's like, I'm driving in the middle of a rural area, like all I really can do right now is FaceTime. I'm like, okay, so I had the patient connect to the doctor on the patient's phone with FaceTime, and we were able to find out what this patient needed and do it. So at least in my peace of mind, I didn't initiate the call. The patient initiated the call to his own provider, and I feel like I get a little more cover, right or wrong, doing that. And one of the things that I actually love about being in telemedicine is not that it's the Wild West, but that it's a little hard to know how to dot all the I's and cross the T's. And if you get creative, you can follow the spirit of what you know to be the rules and still find a way to take care of the patients.
After you. Oh, okay, thanks. Well, just a couple questions actually for you, just to ponder, not to raise hands necessarily on, but the concern obviously is with regard to one of the concerns is with regard to cybersecurity, and actually in 2017, Accenture did a study and found that 26% of people actually had a breach of some type of cybersecurity. So that's one thing to think about. How much do you want your protected health information exposed? Because this is somewhat precedent setting. I mean, we're talking about this particular patient, but we have to think more globally. How, if you were in that situation or your family, that's one thing. But then does it set a precedent for other times that this type of thing comes up? Would you be able or interested in using something that would not be a secure device in a transmission of information? And then another point is, as Jason has already alluded to, would you want a Cambridge Analytica type of situation coming out where you would actually have protected health information divulged unsecurely? How comfortable are you with that?
I think another point to sort of consider is, at the time the legislation came out in 95, the whole purpose of it, in addition to the policy aspects of carrying insurance with you, from a health IT standpoint, it was to make claims transactions electronic, to reduce the burden of overhead. That was the big aspect of healthcare reform, one of the big aspects of healthcare reform that then President Clinton was pushing. And so the privacy and security actions were to be able to protect that data in a claim from being used in an unauthorized way. As we now move into 2018, the amount of data that is available to people has grown in ways we could have never foreseen. It's not just basic claim data. There is all kinds of clinical data that's available. There's genomic data that is now available to you. There is social media data, which, believe it or not, does have aspects of health. You would be amazed at what people will put on Twitter about their health condition, looking for support or looking for issues where they need more information on. The amount of data is substantial. And so I agree with Brian that the rule does need to be revisited to some extent. And I would also probably state that given that the telehealth modalities have increased as well significantly, I mean, back in 1995, having a cordless landline was considered a major improvement. I remember how excited I was that I actually didn't have to be tethered to a phone. Do you remember that, Jordana? Right, okay, so it's a long time ago. Sorry, he made me do it. But now, we have smartphones that we don't use as phones very much. We have iPads, we have, even your gaming system can be used as a communications device. So there are so many sources of being able to connect with people, particularly in the areas of medicine, that it really does sort of not just warrant a revisiting of the rule, but leveraging some of that technology to help assist individuals about how and when their data is going to be used. I mean, it is rather amazing to me that if I were to right now buy $75 worth of Bee Gees songs on iTunes, I would get an alert from Bank of America going, did you just spend $75 on Bee Gees tunes? I mean, please tell us this is fraud and a joke, because we can't believe that anybody would do that. and I'd have to respond yes or no before I got to use my card again. But yet we don't receive those same notifications about your data is being used at this point, at this time, to provide care. Can you authorize this data, or somebody as a proxy is able to authorize the use of that data? And we should be leveraging that ability to do that.
I just have one, go ahead.
I have a
Please.
question for you real quick. So what would have happened if they gave the TPA and, they don't know how much time had passed? What could have happened to the patient?
Hemorrhage.
Died,
Died.
basically, right? If you give TPA, too much time has passed, the hemorrhage, is there any likelihood you could save that person's life?
Statistically, it falls off precipitously.
Yeah, it's basically, with every drug, there's a risk and a benefit. And so once you get past, whatever time, the risk goes up, the benefit goes down, and you change the risk-benefit ratio.
So here's a hot take for all you folks who are administrators or operators of facilities. How would you feel if one of your physicians just said, you know what, I'm going to start practicing and delivering care via telemedicine just on the down low? Maybe we don't haven't implemented our protocols or policies, and this was the doctor. He said, you know what, I don't care. Let me just do an eval on the iPhone. Oh, I can see the guy has some facial droop. Let's push the TPA and the guy dies. Right? I know we're talking about privacy and security, but on the other side, there are real valid reasons why institutions and hospitals and whatnot set some protocols and policies to help control how care is delivered on their site. I don't know how a medical board may respond in that scenario, but I could certainly see a situation where that individual physician is brought up by the medical staff for some review, because they said, look, telemedicine is not, we see the value, it's not yet in our playbook. You went rogue, the patient died, right? Would you like to take the stand and be cross-examined by Mr. McMenamin? I don't think so, right? Right?
He's dying to say something.
Right. Right. Certainly, it could have saved the patient's situation, but there is some real risk to consider here.
Absolutely, and thank you for bringing up Mr. McMenamin, because I was actually Dr. McMenamin, I was going to mention something that he had said yesterday, and that is that the quality of transmission is a major issue. And so, for example, if it's in Rural View Hospital, then you may not have great, the broadband issues may be a concern. You may not have great transmission. Some physical finding might appear to be visualized on the recipient, the vascular neurologist end, but it may not actually be a valid finding. So you really have to have high quality transmission so that you can make a legitimate assessment.
Okay, so Jason, if we wanted the rules to be revisited, what's the steps to doing that? You brought it up.
Well, Natasha's right there. You can ask her. I think, I would have the normal answer for you, but in today's environment, I have no idea how that would get done. I think, to start to begin the process of I don't think it's rewriting the regs, it's altering the reg. That there would need to be somewhat of a coordinated effort by organizations that have, significant influence on how that would get done. So that would include not just telemedicine associations, but I think that would also include AMA and AAP and AARP even. I think some of those organizations that have significant muscle on the Hill about how that would be accomplished, because it would have to be legislation that would have to be brought forth, issuing that there would need to be changes or a new act put into place. That would then have to be designated to HHS to be able to draw up those rules or those alterations, and then that would have to then be finalized. They'd have to go through a public comment period, and then every comment, and I can assure you, because I remember the last time there were, 22,000 comments just on the security rule, and every one of those has to be answered. You can't, the law says you've got to answer all of those. So try being in a room with people answering 22,000 comments. That's not fun at all. I would imagine that nowadays, where there's so much more data that's available, where there's so many more uses of data, and we have been alerted to these breaches of personal identifiable information through Cambridge Analytica. And as I've always said, you always hear about the bad stuff, right? And if you watch some of these commercials about like LifeLock or like the dark web is here, your information is there. You need to subscribe immediately. Like, I mean, it's like this ominous voice of, oh my God, everything that is available about you, somebody is reading that you don't know about. I mean, it could drive somebody very crazy and make them very paranoid about what their data is being used for. So I think that if we want to do this, we need to sort of have a coordinated effort to get legislation drafted.
Okay. So why don't we go to the polling questions now? In the case that was presented here, was complying with the security and privacy regulations more important than kind of doing the right thing and using the technology to care for the patient? So public opinion here. Okay, I think we need to start working on rewriting these regulations.
Well, let's also be aware of the question bias. Doing the right thing is one option versus what?
It's a bias.
I'm leading the witnesses. Okay.
We're gonna reword it as, should we just let the dude die or keep him alive?
Well, it's a tough crowd. So if the physicians in, what's that?
When you said that, it went from 9 to 10%. It went back up.
Well, Joe is going to file a motion to exclude the statement about how he could save the guy as non-admissible hearsay, and it would be a non-issue.
Yeah, I'm glad he's not up here. If the physicians in this case had used their mobile phones and the outcome was better, do you think anybody would have raised their hand and say, hey, I'm going to blow the whistle on them because they did the wrong thing? No, just kidding. For violating HIPAA, so yes or no?
We don't get to discuss
Yeah.
this one?
Interesting.
Can we discuss these?
Go
Or
on.
it's just the poll? Do you want to discuss these at all, or? Well, I just, it's important to realize that you actually can have a waiver for HIPAA if it's something that you can, it's through the Office of Civil Rights, obviously that's where the regulations were penned, and HHS. But the point is, the patient or the family in this case, if they're going to sign a waiver and say, we don't require you to abide by strict HIPAA guidelines right now because we want the communication to take place, they may say that they sign that informed consent under extreme circumstances. It's really questionable whether that would hold up in a court of law. So, it's important to realize the circumstances, and actually and sort of a question for Brian is the fact that why would we want to water down privacy and security when technology can catch up? Technology is going at such a rate in terms of its development, it would seem that wouldn't really be needed. You actually have just technology get to be better. Mm-hmm. And what'd you say?
Yeah.
And as data is the new oil, as they say, and protected health information is actually the most prized data, then we should really maximize protection and not try to lower the bar.
Yeah, I think I would agree with that statement, as a matter of fact. And I know that just to toot the horn of my own members of our association, I know that is they aspire to not only satisfy the law but to go above and beyond. And that can even be a market differentiator for them. But I would agree with you.
I just want to add a comment to this. I don't believe I know a physician or provider who doesn't violate HIPAA on a daily basis. I'm just going to put it out there. Like, at some point, we need to be realistic. I walk into Starbucks to get my coffee in the morning, and there's an intern on the phone doing sign out with another intern, and they're going over medical information. And sometimes I say something, and sometimes I don't. You get in the elevator at the hospital. I'm an emergency physician. There is nothing more violating HIPAA than leaving a patient 2/3 naked in a hallway. It doesn't list their identifying information. It's only their face and their body, right? I mean, there's a little bit of of insanity related to this. And so I think, you know, PHI is really important, and I agree with all the things Marilyn said, but everybody is texting a rash. It's just a rash on somebody's body. Nobody knows whose body it is unless they write, hey, look at Jason's body, you know, in the text message. A whole separate violation. But
Can we see your cell phone, please?
what?
Can we see your cell phone photos?
right. But we're degenerating here. But I think reality is this stuff happens, and people are very good at finding workarounds at everything. And what we have done is we've interpreted a well-meaning regulation as overly stringent because everybody's afraid of the risk. And then what people do is they totally ignore it and find a workaround. So I think if we don't end up in a spot where we can actually take care of patients without providing poor patient care because of HIPAA concerns, people begin to ignore it or find different ways of doing it. And that's actually worse.
To get hyper-technical, the use of FaceTime might not, in this scenario, might not even be a HIPAA violation, right? There's some arguments that some of the just a point-to-point video services that don't store any data or just meet the conduit exception under HIPAA, not requiring a business associate agreement. So let's say you were like super privacy officer at the hospital. We don't want to dot every I and cross every T. And this happens, you could quickly do a review to determine if there actually was any breach, because the mere transmission of data does not mean that there was a breach necessarily, okay, that the data went to someone else. If you find out it did, right, you can then just self-report to OCR and say, hey, look, this guy was about to die. We saved his life. We do think there's an issue. We think it's a non-issue, but in case anyone ever reports to you, go ahead, and I think you would be fine. Mm-hmm. There's solutions to every problem.
So I don't want to prolong this particular part of the session, but the two physicians on the panel, I mean, you're obviously aware of that, but how many physicians do you think that are aware of what was just said by Nate in terms of knowing that you could self-report?
I'm not sure that there are that many, actually. But I do want to couple onto something that Judd had said, because I do think there's an element of professionalism here. That's a huge concern. I think maybe one of the things I was sensitized, just a really tiny vignette, was when I was actually in college. I was a volunteer at a rehab hospital, and I was going around assessing patients for depression. And I went in, and this woman was crying, and her name was I'll just make it up, okay, Mrs. Wilson. I mean, this was like a long time ago, so you wouldn't know her. She's passed on many years ago. But anyway, so let's call her Mrs. Wilson. I would go in, and I saw Mrs. Wilson, and she was crying. I said, what's wrong? And she said, they said Mrs. Wilson is never going to leave the hospital. It was a different Mrs. Wilson. So, I mean, you know, I checked it out and I reassured her, but I think that just heightened my awareness before I even went into medicine, that there's a professionalism and a sensitivity to patients, and there's a way to do things even before HIPAA was ever even developed.
Just in general, do you think the privacy and security laws are helping or hindering telehealth in general? Yeah. So it looks like about 60% suggest they're hindering. So, any response?
Well, the vendors who are here and those who are engaged in telehealth, one would think that they have the highest level of, you know, professional behavior, and they meet the highest level of standards. And why would you want another company or another provider, some other group, to come in and just circumvent all the work that you've done to make sure that things are going the correct and optimal way, and get, you know, into the market or do other things that are not done as they should be? That, I would think, would be not something that anyone here would be interested in seeing.
So moving on, why don't we just hop through the questions, and then because we're going to talk about licensure now. Mm-hmm. So let's get a perspective on licensure, and then we can discuss it. If this case had happened on a kind of a border town where a river runs through your states, let's use New Jersey and Pennsylvania, for example, Delaware River cuts through and divides. So if the neurologist is on the New Jersey side, and of course the patient and the attending physician are on the Pennsylvania side, should that matter? So 3/4 say it shouldn't matter, but we know it kind of does. Panel want to take a swipe at this from a licensure standpoint? Or there's another question for licensure. You want to get them both out there?
Right.
actually want to ask people why it should matter. Do people believe that fundamentally practicing medicine in New Jersey is different than practicing medicine in Pennsylvania? So I get the fact it matters, but I would love if somebody who feels passionately that it should matter would walk up to the microphone honestly and make the case that it matters. I don't think medicine kind of matters. It's medicine. It may be if you're in a setting that doesn't have a CAT scan or MRI, it's different than if you're in a setting that has resource, but I don't see why state borders should matter. Challenging
now
the
you
man.
asked for it. Here we go.
We're in trouble. We're in trouble now. He just buttoned his jacket.
Joe, you can serve him whenever you want to. It's fine.
Hey, Joe, I can do that.
I will say I'm licensed in both states.
My real role here is comic relief. Passionately is too strong a word. There's no question the medicine doesn't matter which side of the Delaware River you happen to be on. I will suggest, though, that the law matters. What we're looking at here is an aspect of federalism. The United States was formed on the principle that governmental power should be limited. One of the fundamental ways that the Founding Fathers saw to do that was to give limited powers to Uncle Sam and relatively extensive powers to the states. The states are jealous of their sovereignty. An important part of our freedoms of Americans is the fact that I am under the sovereign of Virginia, in my case, as well as of Uncle Sam. To the extent that the sovereignty of Virginia, or in this case Pennsylvania, is eroded, and to the extent that the power of the federal government is enhanced, then some measure of the structure that the Founding Fathers created is likewise eroded. Now, I understand, I think as well, reasonably well, what the benefits would be of national licensure or something comparable to it. And I'm not drawing a line in the sand saying thou shalt never do that. I think there could be distinct advantages to allowing it. But let's not dismiss entirely the concept, the tradition of the regulation of the practice of medicine by the states. It has a foundation in bedrock principles that formed this nation.
So, all right, so heaven forbid I'm the one that's going to argue against Joe. And not arguing out of principle, because he's absolutely correct about what he said. My somewhat counter argument to that is that the world of healthcare that we are living in now, as opposed to the world of healthcare we were living in at the time that licensure was created, is vastly different. The technologies were not available. The level of care needed was not as comprehensive as it is now. The idea of care teams, care transitions, people moving in and out of different states for care, the need for extensive emergency response units, first responder care, the types of data that are now available to be able to treat a patient from a clinical and non-clinical perspective were not accessible then. So as times have changed, the law needs to change with the times to some extent. I don't, as somebody who is like you, a very big proponent of states' rights, I think that there is a need at times to have some degree of state authority over licensure. But I also think that because of where we are and because of the needs of our population at this point, and because of the technology that is there to help them, that we need to revisit this and the idea of a national licensure and try to see where we can strike a balance between the two. I don't think we need to erode one at the expense of another, but I do think that we need to at least examine the idea of having a national license. So I equate this a little bit to the project management professional certification. Does anybody have that credential? Right, I have it too. And so they made this huge deal about getting this. Like, this will change your life. Like, you will become so incredibly valuable. All you have to do is pass this exam. And I'm like, I've been managing projects forever. Why do I need this credential? Just get the credential. It'll change everything. So I went to this intensive 1 week training course where I didn't eat carbs for a week. I had to do yoga in the morning and I had to do breathing exercises. I'm serious about this. 5 times a day for 4 days. And then I took the exam on the 5th day and I passed it. And I was so happy I went out and ate 3 donuts right immediately. I eat carbs now, this is great. And I've had it, and it's helpful to some extent only to put beside my name so that when I'm applying for a federal contract, they can see I'm a PMP. And that means that I have achieved some level of competency that they can then award me X number of dollars. And I think that that's fine, except I really think the reason they do this is because I have to pay them every year a fee to maintain that credential, and I have to keep studying on how to be an even better project manager, which of course nobody ever does. Because they don't check it. So I'm honest, Joe, I really am. I don't like to cheat systems. So I write down truthfully what I'm doing. But there's people that write down, like, I watched my cat for a week. I get 2 project management professional credits for doing, and they don't check it. So I think that I don't want to set up a system like that. But I think that there is some way of having a system like that with firmer checks and balances that achieves some national licensure so that when you're presented with cases like this, you can provide care immediately while still maintaining some state right flexibility. And I don't know how to do that. I'm not going to pretend that I know how to, but I think we do.
So,
Brian?
so
Great.
I just want to say one thing, then Marilyn's going to take the mic back. She is, that's fair. But so again, this is one of these things that I'm a real doctor taking care of real patients, and someone signs up on the Jeff Connect app and they log in or they register and they're a Pennsylvania patient and they're now in Florida and maybe they have something that might be serious. Do I say, oops, screw you, I'm not licensed in Florida? Or do I take care of them? Where's my risk benefit of abandoning a patient who actually needs me versus taking care of somebody in a state where I'm not licensed? These are real issues that I need to deal with, pretty regularly. And we need to get some answers to some of these things. I mean, some of the states deal with it, but I think I'm trying to bring it back to the real practical aspects. It's not cut and dry. I have 19 states worth of licenses. It takes a long freaking time, and it will, with the federal compact, still cost me $20,000 a year and take a long time just doing the renewals. It's a hassle. I'm not sure it does any good. I'm pretty sure once I'm licensed in 16 states, the 17th state isn't saying no. And the 18th state isn't saying no. I'm an evidence-based guy. I would like to know how many states have turned down somebody who is licensed in good standing in multiple other states. I would bet it's pretty close to 0.
Brian?
Oh, sure. And
Sorry.
I actually will defer to you on this, so I won't go on too much about it. But just towards finding that balance, there is this proposal from the Federation of State Medical Boards that, well, it's not even a proposal, it's a real thing, it's a compact.
Yeah.
There's an interstate medical licensure compact, which I think you're probably more appropriate to, was that what you were going to raise?
Oh, no, that's fine.
Oh, okay.
I mean,
Go ahead.
I can talk about it, but
Sure.
go ahead.
No, I was just going to say that maybe the interstate medical licensure compact, and I was just looking up on my computer that 22
states, 29 boards.
right, might help strike that balance. Go ahead.
Thank you. Thank you for bringing that up. That's a great point. So one of the reasons I think it's really important to have is a particularly salient, emphasized point for everyone is one of the most important roles, if not the most important role for the state medical board, is to protect the public. And how is that happening? If you may say, oh, look, there are national guidelines for a particular standard of care for a particular disorder, and as long as everyone abides by that, that's fine. What if you are the patient in a particular state and you, through telemedicine, connect with another physician who goes afoul of that standard? To whom would you have recourse? You only have recourse to the board effectively where you are as a resident, and that is the board that would have to have oversight effectively over that physician. So you would be really limiting substantially your ability to file a complaint if somebody went afoul. Also consider the fact that there are different states that have different laws within them that vary from state to state. So for example, aid in dying as a particular example. Let's say you're in Pennsylvania, and your loved one, a 92-year-old mother, you think that she's had enough of life. She really seems like she is ready to go. And you hook up by telemedicine to somebody who's in Oregon, and you say, Mom is ready to go. And that person says, okay, I can help you with that. We have a prescription here for aid in dying. I will prescribe that for you and have your mom at peace. Then later you think, maybe she was just really depressed. Maybe she just needed to visit Aunt Susie and she came around. It's too late because you already took care of those steps that the other physician put forward, and you have no recourse. So it's really important to have local state authority so that you can have recourse if someone goes afoul or if you need to file a complaint. And that is to protect the public.
Now, see, I would actually posit that you don't have to be licensed in a particular state in order to be subject to get in trouble in that state. And the course of action for the patient would be, in most states, right, filing a complaint with the Department of Health for unlicensed practice of medicine. And I think any state could take that as a sanction, whether the doctor, even if the doctor didn't have a license. What I do think, to your point, is let's say you had a national license or the individual was licensed in your state. Then the Board of Medicine's ability to implement corrective action is much more nuanced, because then the individual doctor is subject to the oversight of the Board of Medicine, and they could say, look, it's not unlicensed practice. However, we don't agree with the way you did it. Come before us, let's talk about it, then they'd be able to do a letter of censure, maybe something less than straight up unlicensed practice of medicine, which is like yes or no, and then that's reportable to all of your other states of licensure. So there could be a go-between, but think about this on the dark side. Raise your hand if you work for a hospital, some institution, right? Okay. How would you feel if we snapped our fingers, there was national licensure, okay, and then everybody on this panel, we said, you know what, we're going to go to find the cheapest cost of living town in the country, maybe somewhere in Nebraska, create our own telemedicine-based physician group, right, and just contract with all your hospitals for outsourced staffing, and half of your jobs are eliminated. We have a national license. It's really easy for us to do now, and with all of our doctors located in a very low cost of living place, we can pay them less, and then we charge a lot less for these other hospitals. There are business and bigger implications than just medical board oversight for a total national streamlined license. So you might not even be ready for it from just your job security standpoint.
Thank you for that point. That is definitely a major issue, the lowest common denominator, which kind of ties into the next question as well. Right. I think it's also interesting reading CTEL's comment. You were involved in the CTEL comments on Ryan Haight, right? Were you?
I didn't help draft.
Oh, you were involved in those, Joe. Yeah. So it's interesting because CTEL talks about the fact that one of the foundations that they say is a safeguard that allows them to proceed with a recommendation to the DEA to really open up, the issues on Ryan Haight is that the patient actually has the protection. So they're saying that the practitioner is subject to tort liability and licensure board disciplinary action for failure to comply with laws, regulations, or board policy. So even CTEL, who's a major advocate, as you know, in the telemedicine space, actually recognizes the safeguards that state medical boards play.
So I guess welcome to healthcare. Our tagline is, if we can make it complicated, we will. So should there be national licensure, true reciprocity, or do you think we should continue with state-by-state licensure formats for all types of providers? Public opinion again. Wow, 50% national licensure from the group. The other half, true reciprocity. And where's the 5%? No, just kidding.
I would love the same question pulled at the AMA state legislative annual meeting, Because, those are all doctors and, everybody's entitled to a different perspective, but it'd be
very interesting. Does using only the old-fashioned telephone lower the standard of care when compared to care delivered by an interactive audio and video system? Panel. Well, let's get the answers, then
So I could start with this, I guess.
Well, the crowd thinks it lowers the standard.
Well, it does, I think. I'm just sort of, I'm going to channel our good friend Gary Capistron, who's now retired and hopefully living a wonderful life outside of ATA. When the NQF measure framework for telehealth was released, he was sitting next to me at a CTEL meeting, not a CTEL meeting, an ATA event, and he said, the great thing about these events is that all the experts of telehealth are in this room. And the bad thing about these events is that all the experts in telehealth are in this room. I think we have to be extolling the virtues of telehealth to any of you. We all understand its benefit. Most of you live this on a day-to-day basis. I think what's important to remember is that the standard of care is interdependent on these other two, or it can drive these other two, in that when you demonstrate the effectiveness of telehealth in providing a standard of care that is equivalent to that of an in-person encounter, or that it is the only alternative to receiving care, with the other choice being, as Judd would say, not getting care at all, then you begin to understand why there needs to be a drive for re-examining HIPAA regulations and licensure issues. Because in the time that we are living in now, telehealth is becoming much more prevalent. There is more money being put into it, and it is receiving far more national attention than it has probably received before. And the way that we sort of take advantage of this is that we start driving towards a core set of measures to really be able to understand the impact of telehealth on issues like access to care, actionable information, so information is presented so the physician knows what to do next, information regarding how it decreases travel time, provides more timely care, all of the benefits that many of you understand and have discussed for years. The problem is that people outside of Hershey Lodge aren't going to fully be able to understand that unless there is data that they can look at where they can actually see the effect, where telehealth reduces the amount of time to care, reduces travel, provides actionable information, and saves lives, saves money, increases health, increases quality of life. So if you build those core measures that are able to do that, and at the same time you're able to show that the impact of telehealth modalities on the quality of care is the same as an in-person encounter, then you're demonstrating that telehealth, what the benefits of telehealth are to the larger world. You're building data to make that case. And then the arguments for being able to revisit HIPAA, to look at licensure again, become much stronger. Because when I was at NQF and we had the telehealth framework and we were up on the Hill talking to senators about why there needed to be changes, the first question is, it's not that they didn't disagree. Senators like Brian Schatz in Hawaii, or soon to be retiring Senator Cochran in Mississippi, or Senator Coburn from Oklahoma, they all understand this. There's not a lack of understanding. We need data to show this. We have to be able to demonstrate to people that if we're going to pass legislation, there's a reason why. The only data that we have are a lot of one-off randomized controlled trial studies that have been done by people like Judd or other people that clearly demonstrate the effectiveness at Jeff Connect. I almost said Jeff, almost. But we have to show this on a larger perspective. And I think that if you come to ATA and you hear me speak Monday at 11:30, I will be talking about this, and I'm not going to do the same routine that I've been doing. I've changed it completely. A lot funnier this time. I talk about what we need to do with this framework now that we have it, how we need to drive towards common measurement, how we need to be able to show quality of care is equivalent to in-person. The removal of the GT modifier is a huge step in that direction. And how then we can leverage that data to enact greater policy change that will open up telehealth and expand it in ways that will improve the quality of care overall.
So, yeah, Jason and I do this dog and pony show a decent bit, but I think it's a couple points to add on to what he said, and this question gets at one of them, which is don't extrapolate. So I like to say, let's not compare telehealth to an in-person visit. Telehealth is actually just simply a care delivery mechanism. It's just one way to deliver care. And trials shouldn't be telemedicine versus something else. It should be everything including telemedicine versus everything excluding telemedicine. And then, presumably, more options for patients and better ways of delivering care will fall out to be better. And we need to do those trials. So just like I would say, and Jason got at this, that it's my little simple math. Even if telemedicine in-person, a telemedicine scheduled visit is not as good as an in-person visit, let's say it's 85% as good, okay? If 30% of people have no visit as their predominant option, well, 85% of ideal care beats the pants out of 70% of ideal care, and telemedicine is great. The same thing holds true in this question, so I could pretend I'm being responsive to the question. You can't compare the telephone to telemedicine because everybody has a telephone, and not everybody may have Wi-Fi or broadband access. So it's really what's the best care delivery mechanism for the patient in this situation that they have. And then the other thing that actually nobody's really commented on in any of the sessions that I've been at that I think is really critical is the other thing that has to do with extrapolation. I'll give one example. You all know, whether you're a clinician or not, that high blood pressure, diabetes are bad things and lead to heart disease down the road. What you probably don't know is if I see you in the emergency department with chest pain, it has no predictive value at all whatsoever. It's meaningless. The same things looking for the same disease in different settings may have predictive properties or not. We talked earlier in this particular case that was presented about the risk benefit. So what I know, I'm going to give you two examples. I know in hypertension, based on gobs of data, that if you have two blood pressures that are elevated in the practitioner's office and I treat you and make your blood pressure normal over the next year, you're less likely to have strokes and heart disease and kidney failure. What I don't know is if you have two blood pressures that are elevated in the office, you get remote blood pressure monitoring and it's normal during the rest of the year. Is that different than if it's abnormal during the rest of the year? Because no one's done the studies and no one has actually shown that getting your blood pressure every day from a remote device is better or adds to your clinical outcome compared to just getting it when you go to the doctor's offices. It might or might not be the same. It might turn out that lowering your blood pressure a certain amount is really good, and if I lower it too much, we know it increases your risk of stroke and heart attack and other things. And even take the smart pill bottles. I do a drug trial and I give you drug A, and I tell you take it twice a day for a month. I might know how often you took it. Like maybe you're supposed to take 60, you took 56 of them, and I know that it works this well and it has this few side effects. And now it's on the market. And now I have a smart pill bottle and a text message that makes you take it every day. Maybe your adverse side effects just went up and your efficacy is no better. And maybe you change the risk balance. So we have like a lot of cool technologies out there that might actually work. They measure something. We can show they measure what they're supposed to measure. We don't actually know that those things are good for patients. And so it comes back to what we're saying. It's all care delivery mechanisms, but we have to figure out, is more better? It may turn out that only taking your prescribed medicine 80% of the time is actually the right amount. And if we made you take it 100%, you'd all be dropping dead because nobody's really done that in clinical trials. So just like the cardiac risk factors, we shouldn't assume that this is the same as this, because it's not. And good news for me, I'm a clinical researcher, and we actually need to do all of these studies. And those of you at academic medical centers need to do these studies. I'm not by any stretch saying the stuff doesn't work. I'm just saying I don't know. And there is a real downside that the vendors aren't thinking about. They're just thinking, oh, more blood pressure medications are good. More blood pressure measurements are good. Might be. Might not be.
So should telehealth be held to a higher standard than in-person care? Any really quick comments from the panel?
Just the point yesterday that was made many times, that it's really important to use a reasonable approach to comparing, so that while it's not going to be exactly the same, you need to make sure that it's optimally done and that it's a right way to go about the treatment as well as the prescribing.
Would it be acceptable for the standard of care for telehealth to be lesser than in-person care if the alternative were no care at all?
Right. It is, and I know that there are people who don't have access to health care and they should have access, but at the same time, any of you who is a professional and licensed have ethical standards and rules and whatnot, and any patient who goes to you, or if you're a lawyer, you have a client, you have to maintain a certain caliber of care. And so I think it's a real dangerous slope. Yes, there could be exceptions, okay, Judd? But other than that, it's a dangerous slope to, as a policy, say it is okay for telehealth-based services to be lower than what is acceptable for medical practice.
So I'm not going to argue that because I clearly agree with that, but I will make the point that all of medical practice is a gradation. If you break a bone, you could be seen in the ER, the urgent care center, an orthopedist, or your family physician. I think most people would say, well, the orthopedist is best, but it's not the care model we use every time you break a bone, and the other is good enough. So I'd offer a friendly amendment and see if you accept. There's a bar you need to get over, right? You have to meet that bar, but it doesn't need to be perfect.
I also think it depends a lot on what the patient's expectations are and family's expectations. And if, for example, an entity says that it is okay to be lower, we're going to be setting those wrong. We need to make sure that people understand what the level of care that they're getting through telehealth and what they should be able to expect from it, how it can compare, what the limitations are, and what the potential benefits are. I think there's a lot of education that needs to be done of the public so that they can engage in an intelligent way.
I would clearly say that the efforts to make telehealth equivalent to in-person care are start here. They've been starting here. I've the good fortune of working in telehealth for so long is I've met so many people that have provided care for ages. And, I hear the stories and hear what they're dealing with and hear the real life case studies of what they have to endure on a day-to-day basis. And I think that we've made a fair amount of progress in moving this forward, and I think there's still a lot of work to be done, but I think we have sort of a collective spirit to get that completed. And so I say it's not a unicorn because I'm not accepting this belief that it's some magical, mystical form of health care. It's not. It's a care delivery mechanism to provide care in the same way you would get care, if you were going to see a doctor. So as an example, my son, last week, didn't want to necessarily go to school, which is no surprise. And he said he was really tired. So he pretended to faint because he's very dramatic. I have no idea what side of the family he gets that from. Yeah. But when he was putting on his act, he hit his head against his closet and it cut open his head. Not severely, but it cut open his head and it started to bleed. So I'm, of course, driving to Virginia to start my march for states federalism. No, I'm kidding. Just kidding. I was there for a business meeting. I get a call from my panicked wife who's in Atlanta. Oh my God, he split his head open. Will you please go take care of him? I had to, go get him. He's fine. And so, I could have gone to the ER, which would have taken 3 hours. I could have gone to his primary care physician, which tried to squeeze him in, or I could have gone to an urgent care center. And I'm not a physician. I say this all the time. I'm not a lawyer, thank God, and I'm not a doctor, thank God. But I looked at his head. I'm like, it was just a small cut. I'm like, I just go to an urgent care center and they'll take care of this. And they did. It was just, they cleaned it out. They put staples in his head. He was incredibly amused that he had staples in his head. He talked about it all week. He didn't flinch. He didn't cry. He didn't do anything. And the doctor said grown men weep when they have to have staples put in their head like Judd. I think Judd's point of there's different options available for care. And so there's a bar that has to be set that you have to meet of professionalism, of ethics, of integrity, and of quality. But the means of providing care are very diverse. This would not have, telehealth wouldn't have helped here. I mean, unless Judd's going to guide me through stapling my son's head, which would not have been advisable. But, when those options present, we have to give people the ability to take those options and provide that ability to give them care in a way that is comprehensive and of high quality, where the integrity is being preserved. And
Okay, let's take the best question first. Is there a medical board in Antarctica?
Is there a medical?
Yeah, they're on a hiring freeze.
I could probably pick out the individuals that voted that up. What was that?
they're on a hiring freeze.
They're on a hiring freeze.
This is terrible. It's a terrible job.
I have lost control of the panel.
The total dad joke.
The first one's kind of interesting, Nate, and I think that kind of falls to you, leaving aside what is right and what is wrong. Which is the worst lawsuit to be a defendant in, breach of privacy or negative health outcome?
There's no right or wrong answer. It's how culpable you are. There's causation elements, but let's change negative health outcome to responsible for someone's death, and I would much rather be a defendant in a breach of privacy, because we're not talking about human life. What are we talking about here?
That's right. Okay. I don't know. I don't have the answer to is FaceTime encrypted and HIPAA compliant. Do any of you know that?
This is going to go in my office.
Is FaceTime HIPAA compliant?
Right,
Okay.
and so it could meet the conduit exception, but for the fact if you have iCloud backup, and iCloud backup is automatically defaulted on when you purchase or upgrade your phone. And so you could turn it off and have a scenario where you could meet the conduit exception, arguably.
Okay, so you're saying that FaceTime is recorded if it's going through the cloud?
I'm saying it has the potential to
Has the
back
potential.
up the data through the cloud or the images or whatnot. That's like one of the hooks. And I would imagine Apple is eventually going to deploy something that they externally brand as HIPAA compliant, just like Skype did with Skype for Business.
Mm-hmm.
Hi, I'm Lauren Purnell, and I just wanted to say hi. I happen to have just done a research project on the HIPAA compliance of FaceTime, and there's a really helpful guidance that came out in January from the Department of Defense. It's on their website. It says they find FaceTime HIPAA compliant under specific conditions, and it's all listed out.
Let's thank the panel for all of their input on this.